briefs, but for purposes of today, we'd like to focus on the second issue, which is whether the trial court abused its discretion by allowing the state to call a witness that was called for the sole purpose of introducing a prior inconsistent statement that would not have otherwise have been admissible. This is a case about a very tragic accident and a rush to judgment that happened afterwards. On the day of the accident, Mr. Lawrence was left in charge of the victim and his twin brother, both babies, and their guardian, who was Mr. Lawrence's girlfriend at the time, Ms. Hill, went to work. At some point while watching the children, Mr. Lawrence also received a phone call from his employer and had to leave for several hours. Prior to leaving, Mr. Lawrence got permission from Ms. Hill to leave the children with someone else, and Mr. Lawrence proceeded to ask another adult at the residence, Jerry Knox, to watch over them. He left for approximately 2 hours and returned later to find, obviously, a very tragic situation with the child being injured. Mr. Knox originally denied to law enforcement that he had been asked by Mr. Lawrence to watch the children, and that is when the state of Florida sought blame through Mr. Lawrence. However, in this case, and what's relevant to the instant issue, is the fact that the day prior to trial, the assistant state attorney on the case made contact with Mr. Knox and was advised that he would be changing his story, that he had actually been advised and had been asked by Mr. Lawrence to watch the children, and that is what he would be saying.
That's what you're talking about. What was offered in the proffer, right? Where Mr. Knox said outside the jury's presence that this is what happened between me and the ASA yesterday.
Correct, Your Honor.
And so, one question I have is what is the trial court's obligation there? I mean, surely he doesn't have to believe that. I mean, this is a witness who had some credibility issues.
Absolutely.
And the trial judge made a finding that the state did not, in fact, call him just for impeachment purposes. And he did that, it's not entirely clear, but at least partly based on the representations of the prosecutors that they weren't sure what he was going to say, or he'd kind of been all over the place. And so what do we make of that? I mean, I assume your position is not that we're obligated to find, that the trial court was obligated to find that Mr. Knox's proffer was correct.
And that's correct, Your Honor. There are several things that the court is supposed to consider in these situations, and I don't believe that the trial court fully considered each of those issues. And I'll touch briefly on the statements that were made by Mr. Knox in the proffer, along with the state attorney at the time, because that is one of the factors that the court is required to consider, whether or not this was a surprise, whether or not they knew before trial that this witness was going to say something different. And the importance of that in this situation is the trial court, in finding that this testimony was going to be admissible, made several different findings, but ultimately, and I just want to quote what the trial court said, "I think that the truth coming out is more important than objections that have been raised so far." And this is on page 116 of the trial transcripts. And I think that's important because the trial court is essentially saying that regardless of the objections, the legal merits to the objections, we're not really even going to consider those, because we want to find out what happened to this child, this horrible, tragic accident. We need to find out what the truth is. And if that means we have to have this witness come in and bring in his recorded previous statement to impeach him and then let the jury hear that statement over and over again, then that's what we're going to do. And I think that's where the error lies, particularly. And in regards to whether or not the state was surprised by the change in Mr. Knox's testimony, yes, the court made some statements about Mr. Knox being inconsistent. However, he was not inconsistent in his statements that he had told the assistant state attorney that he was going to testify differently. And when given the opportunity to refute or deny that conversation happened, the state attorney never did that. The state attorney did not deny that they met the day before, didn't deny that he had explained to her that he was going to testify differently. Instead, the state just offered reasons about why his testimony was crucial to their case and why they should still be allowed to call him, even if this change in testimony is what it's going to be. So based on those statements and those facts support the fact that the state was not surprised. There are 3 other factors that the court is supposed to consider when determining if this witness was called for the sole purpose of using his prior inconsistent statement. And the first factor is whether or not the witness's testimony affirmatively harms the calling party. And I think that's the biggest factor that weighs in Mr. Lawrence's favor on this issue, because the state's burden was to prove that Mr. Lawrence acted with willful or culpable negligence, and that resulted in the harm to the child in this case. Now, the state's entire theory was that Mr. Lawrence left the child for 2 hours unsupervised in an unsafe environment. Mr. Knox coming forward and saying, well, he asked me to supervise them, throws a wrench in the state's entire case, their entire theory, and they would not have been able to make that same argument unless Mr. Knox's prior statement came in, and then it becomes a question for the jury of, well, you heard his prior statement, when's he telling the truth? If that statement had never come in, as the state attorney even admitted during the conversations about whether or not the testimony should come in, and I'm referring to page 114 of the trial transcripts, and this is a quote, "So to leave out his presence and what his involvement is leaving a huge gap, leaving a huge reasonable doubt from the state that we need to cover. I think it's also arguable that at a judgment of acquittal, without calling Mr. Knox, we're not eliminating that reasonable hypothesis of innocence." At trial, Mr. Knox unequivocally testified, "Were you asked to watch the children?" "Yes, I was." Previously, he unequivocally was asked by law enforcement, and this is the statement that came in that was so damaging, "Were you asked to watch the children this day?" "Absolutely not." And those statements contradicted each other, and as admitted by the state attorney, that was detrimental to their case. They would not have been able to prove their case unless that prior inconsistent statement came in, because their entire theory went out the window.
Well, they would be able to, I mean, are you saying that without this witness's testimony, you would have been entitled to a judgment of acquittal?
I am, Your Honor, and I think that the record supports that fact, because during the judgment of acquittal argument, the trial court, after the arguments had been made, one of the reasons that the court denied the judgment of acquittal was because there was a dispute of the facts surrounding whether or not Mr. Knox...
We wouldn't be bound by the trial court's rationale on denial. Your client, I mean, this was a terrible case. It was a terrible tragedy. But essentially the facts, other than whether someone was asked to supervise, are really not in dispute, right? The appellant left the home. I mean, your client left the home. He says after asking and making sure somebody was watching the children. He was gone for 2 hours, and he came back, and the child was either deceased or, well, brain injured.
Correct.
Now, your client himself gave different statements to the police, right?
That is
He
correct.
first said he was in bed with the child.
That is correct, Your Honor.
So, wouldn't that go to the jury even without the statements by the witness, the contradictory statements? Assuming we ruled your favor on impeachment.
Correct, Judge. So,
You'd be entitled to a new trial, not a judgment of acquittal.
2 points, Your Honor. First, your comment about whether or not you'd be, whatever the trial court said during the judgment of acquittal, you're obviously not bound by that, and I agree with that. I think, though, that the comments that were made are noteworthy in this specific situation, because I think it reflects the environment at the time when all of this was actually happening at the trial. And the reason...
But let me just clarify. If we ruled in your favor on the impeachment witness theory, you're not entitled to a JOA. You're arguing for a new trial, correct?
The normal procedure would be to grant a new trial on this specific issue.
And that's what you've asked for in this case, right? I mean, just to be clear, you're not asking us now to grant, I know you've got a separate JOA issue, but on the impeachment thing, you're not asking for anything more than a new trial.
The two issues that were raised in Mr. Lawrence's brief, I believe it was issue 2 and issue 3, was the judgment of acquittal. They kind of coincide with one another, because if Mr. Knox's testimony had been left out, there would not have been enough evidence to convict Mr. Lawrence. And going back to Your Honor's question about the inconsistent statements of Mr. Lawrence, he never once made any admissions himself about this was my fault or I was there when the child fell. All the statements consistently show that somebody else was...
the state had evidence that your client was at that other person's home doing yard work, right?
Correct, Your Honor.
I mean, your client gave inconsistent statements about whether he was there or not. So that would go to a jury, wouldn't it? Even without this arguably inadmissible impeachment testimony.
Respectfully, I tend to disagree with that, only because the remainder of the state's case, even those statements were not offered to prove the state's case or to help meet their burden. They were offered to show that Mr. Lawrence had something to do with this. Those specific statements don't tend to show or offer any proof of the specific elements that the state was required to show.
Well, on I don't want to tie up too much of time, but on a culpable negligence theory, if the state had, the child was, mortally injured, your client first said he was there, and then if I'm not mistaken, he later acknowledged he wasn't there. Maybe that's when he said, well, I asked this person to care for them. The state produces evidence he wasn't there, and the child was therefore left alone. I mean, that would go to a jury, right, as to whether your client was telling the truth or not. If he was, then either he was there or he asked somebody else, and I'm not sure that would even come in on behalf of the defendant. And the child was injured and was not attended to.
I still don't believe that the case, if all of this considered was excluded, would have gone to the jury, mainly because, as even acknowledged by the state, this was a case where there's no direct evidence that this caused this, which caused this, which caused this. It's completely circumstantial about whether or not Mr. Lawrence is guilty. There was a reasonable hypothesis of innocence that was never refuted, and under the law, judgment of acquittal, the trial court would have had to consider that, and without Mr. Knox's statements, would have, even based on the record and the trial court's own statements, that was the determining factor, was Mr. Knox.
All right, well, the reason I asked was it goes to the factor on harm, but go ahead and continue.
Absolutely, Judge.
Thanks.
Now, just going back, there's two other factors that the court's supposed to consider on the impeachment issue, and they kind of coincide with one another. It's whether or not the impeachment of Mr. Knox was of a de minimis substantive value. And the record is very clear that this is not one of those situations. This was the centerpiece of Mr. Knox's testimony. He was called for no other reason except for what happened on that day.
Well, I don't disagree with you that it was, I don't think this is a harmless error issue or anything like that, but they still could have called him for these other purposes. He's the person who made the 911 call. He could sort of set the scene as to what he found, whether or not he had, been asked to watch the child or not. I think there was still some value to his testimony. So my question is, how do we fit that in with the cases that talk about that being a factor, or use the term solely for purposes of impeachment? I think even if it were wrong to, even if you were right about what the state knew or should have known, or I don't think you're arguing, or maybe you are, that they couldn't have called him. Period.
No, Your Honor.
Okay.
We're not.
And how does that fit in with this inquiry? Once you get your foot in the door, then can you go off in this other direction, or what do the cases say about that? Because a lot of them do talk about you can't call someone solely for,
Absolutely, Your Honor. And I do think that what Your Honor said is correct. There were other things, minor details about that day that he was able to confirm. Some of the factors that are looked at, though, in terms of that is whether or not his testimony could be considered relevant or probative on facts that are in dispute. All of the other little facts or details that he testified about were not things that were going to make or break the case. They weren't things that were actually in dispute. It was things that everyone agreed on and could have been testified to by other people. I think the issue is, yes, Mr. Knox could have been called as a witness. He could have been called to talk about the fact that he was there that day, that he went and picked up Ms. Hill from her job, that sort of thing. The issue is solely about what the state was allowed to do once they called him as a witness, and would they have called him if that wasn't their intent. The record reflects that they probably would not have called him except for his inconsistent statement, because the other statements that he made were not wholly important to their burden in this case.
If they believe, that gets back to sort of the first issue. What is the state's obligation when they have someone who's told 100 different stories, and then the day before trial says, hey, FYI, if you call me tomorrow, this is what I'm going to say. Are they obligated to say, well, take that to the bank and say, well, that's definitely what he's going to say? Or can they say, in good faith, we don't know what he's going to say? And that, I think, is sort of the critical piece of this particular case.
And I agree with that, Your Honor. I think that with the record that we have, and just going off of what we know, based on those conversations, the record supports that the state knew. They had really never spoken to him before, and they knew that he was not going to give a consistent statement with what he had originally told law enforcement. So I think just based on those collective factors, the record shows that the trial court abused its discretion, if it gave any discretion to these specific issues. And one of the points that Your Honors had brought up before is what is the remedy for all of this? What is the error? Is it harmless? And this is not a situation where this is a harmless error. If Mr. Knox's inconsistent statements had not been admitted, they would not have been able to prove their case against Mr. Lawrence. And this is indicative by the record because of the state's use of Mr. Knox's testimony throughout their case, throughout their closing argument. The state relied on it during their judgment of acquittal. The trial court acknowledged Mr. Knox's statements during its denial of the judgment of acquittal. And then, like I mentioned, during closing arguments, the state made Mr. Knox's statements the highlight of their entire argument. They started their argument, and I quote, "I want to start with a quote from Jerry Knox. When somebody is in charge, they're supposed to be looking out for the baby. I know that. Even Jerry Knox knows that. But he had never watched those babies according to what he said to law enforcement." That was the first statement that the state made during their closing argument. Then, throughout the remainder of the closing argument, the reference to the baby being left unsupervised, the child wasn't left with anybody, nobody was there when the baby fell, nobody was left in charge. He said to law enforcement that he never watched those babies. The number of times that the state was allowed to rely on those statements just shows how prejudicial this was. And the word unsupervised throughout the state's case, when Mr. Knox changed his story, that word, it affected the state's entire case. And it essentially destroyed their theory that they had argued from opening statements through closing arguments. So it is our position that Mr. Lawrence was convicted because of the state's ability to call Mr. Knox and introduce his prior inconsistent statement. And if that had not been introduced, it is also our position that Mr. Lawrence would not have been convicted. So we would ask the court to find the trial court abused its discretion by allowing this impeachment evidence to come in not only as impeachment evidence, but as substantive evidence and the recording of the statement, and either grant Mr. Lawrence a new trial, or in the alternative, without this evidence, we would submit that the state did not sufficiently meet its burden, and as a result, we would ask that the court alternatively vacate Mr. Lawrence's judgment and sentence. Thank you.
May it please the court, Virginia Harris on behalf of the state of Florida. Appellant left out something rather critical, and that is when Knox testified, he ended his testimony by saying he wasn't responsible for watching the babies. And I don't mean from impeachment, I mean in his direct testimony. On 127 of the record, the jury posed questions during the trial. The judge said on their behalf, "On the morning of the incident, did you think you were responsible for watching the twins?" Knox says, "No, sir, I have never watched the children, not babies like that." The judge then says, because they're so frustrated because he keeps changing his testimony, "I guess what they're asking, at any point during the morning, did you think you were responsible for the twins? They was all right, they was in the bed, that's all I can say." So he ends his testimony by saying he was not responsible for watching the children. So he provides direct testimony in favor of the state, and that's the last thing on that subject that the jury was left with. The defense even gets up and talks to him again and doesn't touch that. In addition to that, the defendant provided 4 versions of events. One was that he was in charge of the baby, as you know, taking care of the baby, which is direct evidence. Regardless of the fact that he changed his testimony because it's in the light most favorable to the state. Then he says Marquise was watching him. Then he says Deontay was watching him. And then he says Knox was watching him. When Knox testified, and this would be on pages 114, 121, and 122, he indicates that the children, these 2 people would be considered the children of his girlfriend that lives there, Miss Hill, were all sleeping and nobody was looking in. So he's also providing testimony to refute, even though the appellant seemed to focus on Knox in the trial, his other statements were still introduced. So that's also probative because he's saying these other people weren't watching the baby either.
Are you saying that's probative to whether or not they should allow the impeachment, or you're not making it?
No, I'm saying this witness did not just provide impeachment. He changed his testimony at the end and said that he was not watching the children.
Well, but that was not, I mean, I think what he said at the end, I mean, he's certainly not completely consistent in what he's saying, but the impeachment testimony was, I think you would agree, the most damaging, where he explicitly refuted the theory that he was asked. I mean, you could be asked to watch it from the defendant's perspective if he, you know, not,
He said, I have never watched the
he
babies.
says they've never watched it, but if the defendant's leaving the house and his theory is, I asked him, hey, will you keep an eye on these? And the guy says, yes, that is a factor that would play
Well,
into the criminal culpability.
I don't agree. I mean, this is in direct response to, were you responsible? And he says, no, sir. I have never watched the children, not babies like that. I mean,
But
that's,
wouldn't the inquiry for the jury, and again, I'm not,
yeah.
the inquiry would be what the defendant's understanding was, and you could have a situation where a defendant thought somebody else was responsible, and that person thought he or she was not responsible, and as a result, you end up with a tragic accident, but not criminal culpability.
And it's the-
and I'm not saying that's
Yeah.
what happened here, but
Well, the problem is the defendant destroyed that by providing 4 different stories. If he had really left Knox in charge of the children, why did he initially say his first story that he was there, putting him in charge, but in the bed, and then saying 2 other people before Knox? So
That's-
he's actually the one that really destroyed that. In fact, defense counsel argues during closing argument that it was unclear from Knox's testimony whether he was asked or not because he didn't want to take responsibility. So appellant seemed to agree with me at the end that it was unclear what he was saying. Also, this was not a wholly circumstantial evidence case, so the state didn't have to rebut a reasonable hypothesis of innocence. The defendant, his first story puts him in charge of the babies. Also, he is on video reenacting what happened, and you really have to see the video. The bed is up against the wall, and the headboard is loose. And the officer kind of says, look, this headboard is loose. And he says, oh yeah, normally we have these pillows here showing that it's blocking the space, but I picked it up and moved it over here. So we have direct evidence by his own statements, because Knight has indicated that it's whether or not the defendant's participation is wholly circumstantial. His participation is not wholly circumstantial. But even if we did have to rebut a reasonable hypothesis of innocence, then we would have by his own inconsistent statements. But in this case, and then the case they rely on in Bradley and the reply brief to support their claim, it indicates even if a witness is called by a party for the primary purpose of introducing impeachment, but that party gives relevant testimony probative of facts in dispute in addition to impeachment, no error. It doesn't even say it's harmless. It says no error, and this witness did. Now, going back to the prosecutor, she clearly says, and I have this quoted on page 23 in my brief, that Mr. Knox's testimony was never clear from the beginning whether he was saying he was responsible, the defendant was responsible, or Marquise or Deontay were responsible. So she does refute Knox's contention that she knew he was going to say that. And then also, it took Knox about 3 or 4 times to say that he told the prosecutor that. The defense attorney asked him, I want to say probably about 3 times, did you speak to the state about your testimony? And the first 3 times, he says no. It's only about the 3rd or 4th time that he finally says, oh yeah, I did talk to her and I told her that. So there's no wonder why the judge would have believed the prosecutor over Knox. And then also, the defense attorney did not challenge this until the middle of the testimony. If everybody was really on notice that Knox was going to testify for the defense, why didn't he challenge it before? He was waiting to see what Knox was going to say too, because he didn't even know what Knox was going to say. When you're a defense attorney and
well,
you
but
have
he wasn't party to the conversation the day before. I mean, I guess that would be.
Well, I know,
their
but you
answer
can
to it.
challenge it. When I was in this situation, when I was in the trial court, I would have had a sworn statement or a deposition from that witness in favor of my client. And I would walk in there and say, this witness is going to say this, and the state knows this. I've put them on notice, and they're still calling him. And there was nothing about that. In fact, there was no indication from the defense that he was even going to call this witness in his case, which is pretty strange if he knew that this witness was going to testify on his behalf.
But it's not what the defense knew, it's what the state knew, right? I mean,
Right, but
okay.
that is based on what Knox said after he said 3 times before that he hadn't talked to the state about his testimony. So,
But what do you say to their point that the state attorney didn't dispute any of this? I mean, you have.
she did dispute that.
Well, she doesn't say we didn't have a conversation. She doesn't say we didn't. he didn't tell me this is how he was going to testify. She says he was kind of, what did she say exactly?
I'll quote it exactly. And this is on 23 of my brief, and I have it on the transcript of 116. Yes, sir, Mr. Knox's testimony hasn't been clear from the beginning what he would and would not say. And he made multiple statements to me that were unclear, even to me, about what he was trying to say. Whether or not it was him that was supposed to be watching the baby, whether or not it was Mr. Lawrence that was supposed to be watching the baby, whether or not it was Deontay who was told to watch the baby, or whether or not it was Marquise who was told to watch the baby. So she's saying he was unclear. That disputes what he says. And the record supports that. As a final note, in terms of sufficiency of the evidence, Barton, which is in my case, indicates that even if there was error when considering a sufficiency of the evidence claim, that you're to consider even erroneously admitted evidence. But as I indicated before, this was not erroneously admitted. I don't have anything further. Do you have any further questions of me? We ask that you affirm.
Thank you.
May it please, court? Just want to touch on 2 points that were discussed by the state. The first one is the kind of question of why, if this is actually what happened, why wouldn't the defense have brought this up earlier? Why would they wait until the middle of the testimony? I think that that assumes a lot of things that aren't on the record. It assumes that the attorney for Mr. Lawrence knew that this conversation had happened with the state. It assumes that there had been, Mr. Lawrence was a party to the conversation, or his attorney was a party to the conversation. And it assumes a lot of things that we don't have access to, and that is not what the factors that we're supposed to consider reflect. The second point was in regards to the state attorney's response in regards to whether or not she knew. I think that the record is very clear, it speaks for itself. However, just to point out, the fact that a witness has had several inconsistent statements over a period of time is not the same thing as having a conversation with them the day before trial when you are preparing your witnesses and they tell you 24 hours before trial that they are changing their story, and that is what you are entering the trial under the belief of.
What do you say to the point that the case that says if you call it for any other purpose, if there's any other purpose that would be permissible, that there is no error? That sort of gets back to what I was talking about before, the cases that talk about solely. Do you have authority that would suggest to the contrary? That, I mean, I can imagine a circumstance where, you know, the state is actually calling someone for something that everybody knows they would never call him or her for in some other circumstance, just to sort of defeat that. But what are the parameters of that, or do you know?
Your Honor, I think that is, and I believe that was discussed in the Bradley case, that is just I believe it's one of the factors that the court has to consider. And I think that along those terms, the courts have discussed the fact that the substance of the other testimony that they would give is important for the court to consider. The relevancy of their other testimony, the probativeness of their other testimony, and if it's about a matter that is in dispute.
But not that it's a binary, if you have 1% relevance, then
Correct.
Okay.
I don't think there's any sort of measuring scale about to what extent the witness has to give you other testimony. I think it's just one of the factors that the court can consider. And in considering that in this situation, the other testimony that Mr. Knox gave was not of a substantial nature at all. So the only reason that the state would have called him would be to get this inconsistent prior statement in. And as I asked previously, if the court would either grant Mr. Lawrence a new trial or alternatively vacate his judgment and sentence. Thank you very much.
Thank you. The court is in recess. Thank you for your arguments.
All rise.